I am Ryan McKnight.
I'm Cara Santamaria.
I am Christopher Smith.
Hi, I'm Andrew Torres.
This is Naked Mormonism,
the serial Mormon history podcast. Inevitable is a dreaded word. Rarely is inevitable associated with something that's good for everybody. I mean, even stating that like victory was inevitable implies that defeat was inevitable for half of the players. Inevitable doesn't care what we think or what we say or do to mitigate its power. It just is. We can fight inevitable, and some of humans' greatest achievements have been accomplished in the face of seemingly inevitable defeat, but that seemingly is a powerful modifying word when we talk about inevitable. The Nauvoo Expositor had been destroyed. The Fosters, the Higbees, the Laws, and Joseph H. Jackson were the primary enemies of the prophet. Battle lines had been drawn, the tribes had balkanized, and conflict was inevitable. The mad tyrant's reign would inevitably come to an end one way or another. We know the inevitability of the situation, but absolutely nothing was set in stone on June 17, 1844. Joseph Smith was again under arrest, and he was headed to the Nauvoo Municipal Court with 17 of his co-conspirators on charges of riot. The list of options that Joe had to escape the legal charges was growing rather short. The anti-Mormon political party in nearby Carthage, Illinois, were gathering strength and reinforcements from Missouri, and many of those reinforcements from Missouri were still smarting from the Missouri Mormon War and the attempted assassination of former Governor Lilburn W. Boggs. Everybody in the state wanted Joseph Smith to be held to the same system of laws by which everybody else abides, and the Mormon leadership wanted to be allowed to do whatever they pleased with impunity. Those two concepts can't exist in the same time and space together. What was Joe to do in the face of the immovable object of the law impeding his unstoppable force of a Mormon revolution in America? He'd laid out the options for himself and the leadership, who was still in Nauvoo, which was a skeleton crew at the moment. First option was what was undertaken, and the remaining options would be contingent on the success of the first option, which was to handle the case in the Nauvoo Municipal Court. If that was successful, business could return as usual, and Joe would need to employ stricter control over the city. If the case was officially thrown out of the Nauvoo court on the charges of riot, and the circuit court at Carthage didn't seek overruling the power of the Nauvoo court, that would set a precedent of the Nauvoo City Council's ability to quash any rival papers or any dissenting movements in the city and allow them to harbor fugitives like Jeremiah Smith from justice and to manufacture and trade counterfeit coins from that point forward. This was a precedent-setting month of 1844. The result of this, however, would be vigilante justice, of course. The non-Mormons of Illinois would exterminate the Mormons, as had happened in Missouri as a consequence of the Mormon leadership's lawlessness in 1838. And events were coming to a head, revealing that a similar fate was seemingly inevitable. This meant that any calculation of risks, actions, and results had to take into account the next Mormon exodus. Another exodus had been in the works for at least 6 months. California, Oregon, Mexico, Texas, anywhere the rule of law wouldn't be enforced were locations the Mormons had sent scouts to find the location for the next Mormon settlement. The Expositor being published and the Mormon leadership settling on an act of tyranny accelerated all of these settlement plans. If justice was to be served on the prophet and his leaders, they'd escape and command the saints to once again resettle in a location where justice couldn't find them. So, the plan to get the Nauvoo court to dismiss the charges had been implemented once, but Joe met with a fellow master in the Nauvoo Masonic Lodge who advised him to have a more legitimate hearing, and Joe took that advice into consideration. June 17th was the date of this second hearing within a week on the charges of riot for destroying the Nauvoo Expositor. The proceedings of the court were recorded and published in the Nauvoo Neighbor in hopes that distribution would calm the growing tension in nearby Carthage and Warsaw, and that they would stop sending constables to Nauvoo to try and arrest Joseph Smith and bring him to the circuit court in Carthage. The court convened, and 18 men were charged with riot. under the arrest of Constable Joel S. Miles, who was a Joseph Smith crony. Now, I want to read the names of all of the 18 individuals here who were in league with the prophet for this charge of riot. Why read their names? Well, we get the illusion that this was just Joe and Hiram who were responsible for burning the Expositor press, and then they went to Carthage and they died. But the truth is that without a cacophony of sycophants cheering them on, the Expositor press never would have been destroyed, and June 1844 Illinois history would be much different than it is today. These are the enablers who stood by while a tyrant squashed his enemies. Maybe some of you are descended from some of them. Quote, State of Illinois versus Joseph Smith, Samuel Bennett, John Taylor, that's the second prophet of the Utah movement, W.W. Phelps, Doubled Up Phelps, Hiram Smith, Hiram sidekick of Biff Smith, John P. Green, the marshal of the city, Stephen Perry, Dimmick B. Huntington, Jonathan Dunham, Major General of the Nauvoo Legion, Stephen Markham, Piggy Bank Steve as we call him, Jonathan H. Holmes, Jesse P. Harmon, John Little, Joseph W. Coolidge, Harvey David Redfield, Orrin Pistolpack and Porter Rockwell, and Levi Richards, end quote. These were the men, quote, brought before the court by Joel S. Miles, constable of the county, end quote, on complaint of a guy named W.G. Ware, and these charges were, quote, for a riot committed in the city of Nauvoo by forcibly entering a brick building occupied as a printing office and taking therefrom by force and with force of arms a printing press, types, and paper, together with other property belonging to William Law, Wilson Law, Robert D. Foster, Charles A. Foster, Francis M. Higbee, Chauncey L. Higbee, and Charles Ivins, and breaking in pieces and burning the same in the streets, end quote. The operative pieces of these charges will figure quite heavily into the hearing today because it wasn't just destruction of the press, but it was also the destruction of the building and the other property that belonged to the printers that were in the same office. Now, we'll get into it in the hearing, but essentially the printing press was just one item worth money that the mob destroyed, but they also burned and stole a bunch of other stuff in the office. The defendants retained George P. Stiles as their legal counsel, and, of course, another Joseph Smith crony, Edward Bonney, served as the prosecution on behalf of the state of Illinois. First witness was called by the prosecution, and already some waffling was going on. Quote, W.G. Ware sworn, said he was present when the city council passed an order for the destruction of the press, went up to the temple and heard the marshal read the order of the mayor, did not know how they got into the building. The press was taken out and destroyed, end quote. So W.G. Ware is the person who filed the charges originally, of course, being a Joseph Smith crony, and he was the opening witness of the prosecution. He's not exactly a star witness for the prosecution to call and to make this case, right? The material facts at issue here are the legality of the order of the city council, which caused Joe to command the city marshal to destroy the printing press, and the destruction of property other than the printing press itself, which included forcible entry into a private residence and the destruction of other property inside the building that was housing the printing press. So, the opening prosecution witness gave absolutely no illumination to any details of any of those material facts. Everybody in this courtroom were Joseph Smith allies, and they were trying to shield him from prosecution. Of course, we wouldn't expect this to be conducted fairly and in view of actual justice. This was Joe's court, and they were going to do whatever necessary to achieve the verdict that he wanted. Immediately, George P. Stiles objected to W.G. Ware's testimony because he started to read out the names of those involved in the city council meeting, which passed the ordinance and determined that the expositor was a public nuisance. In Stiles, of course, he is the defense attorney. Apparently, Stiles did not want the members of the city council named in the hearing because that would put all of them into the realm of accessory to the crime of inciting riot. George P. Stiles himself was included as one of the aldermen who voted in support of the expositor's destruction. And if this first witness started naming names, people would look around the court and realize that everybody involved in the hearing right in front of them were all accessory to the crime in question. They all knew they were guilty of the charges, but having all of their names read out in the court would pull back the veil of this kangaroo court. To substantiate his objection, George P. Stiles read some legal doctrine concerning the technicalities of riot, stating, quote, there could be no accessory, end quote, because riot apparently isn't a premeditated crime, so there can't be accessory to it. But that was his line of reasoning, and it's absurd at best. But the court spent some time deliberating about this claim, whether or not there can be an accessory to riot. So Bonney, the prosecuting attorney, read the legal statute, quote, and pled there might be an accessory to a riot. Court decided there might be an accessory to any crime either before or after the fact, end quote. So the defense attorney, Stiles, his objection that the riot charges couldn't have accessory participants, and the prosecutor, he made that objection, and then the prosecuting attorney, who was also Joseph Smith Crony, read the actual words of the criminal statute, and then everybody agreed, yeah, sure, maybe there can be accessory to riot, like there can be accessory to any crime. Oh well, whatever. And then the court proceeded by allowing W.G. Ware to name just a few of those people who voted the expositor as a nuisance. Quote, witness knew some who voted for the order in the city council, heard General Dunham, that's of the Nauvoo Legion, give orders for the destruction of the press. Dunham, Redfield, and Richards, that's Whiteout Willard Richards, took an active part in the destruction of the press, did not know all persons, end quote. So once again, the first witness the prosecution brought was an eyewitness to the meetings who simply couldn't recall everybody connected with the crime. Amazing. Of course, the court could subpoena the city council minutes that we read on the show a couple weeks ago, but Joe's Nauvoo court would never subpoena any document which might incriminate him or his fellow yes-men. So W.G. Ware, the witness, was cross-examined by the defense attorney George P. Stiles. Quote, city council considered the press a nuisance and ordered it to be abated, was present at the execution of the mayor's orders, which means he was actually part of the mob that destroyed the press, no unnecessary noise, all was done peaceably, saw no disorder, heard no language by the prisoners calculated to disturb the peace, end quote. Okay, so these are all just lies. Okay, so the city council, yes, it declared the expositor a nuisance, but everything Ware said after that, it was all either slanted truths or outright lies. First off, a riot did happen, so there was unnecessary noise, and it wasn't done all peaceably, and there was disorder, right? But the court was doing its best to paint the printers of the expositor as the creators of the riot, not the people who were destroying their property. And, that kind of presents a crazy catch-22 that we're trying to set up here. It's like, hey, we can destroy your stuff because Joe said that we can destroy your printing press, but if you say anything about it and get people mad and riled up about this, we're going to charge you with riot. And of course, anybody who could contradict these assertions wasn't called in to testify in this hearing. So none of the printers of the expositor who suffered the criminal act were even called in to give their side of the story. So the court, reflecting, quote, heard no language by prisoners, Joe and his friends, calculated to disturb the peace, end quote, that could not be declared lies by anybody, even though it was absolutely a lie. Similarly, with, quote, no unnecessary noise, always done peaceably, no disorder, end quote, and everything else of the cross-examination record contains. The people who were there, who were the victims of the crime at the center of this hearing, weren't called in to testify. They couldn't give their side of the story. This is what happens when courts are working with results-driven agendas. We get a slanted, bastardized version of the truth, and that asinine interpretation of the facts becomes law. Next witness to the stand in this farce of a hearing was Henry O. Norton, who said, quote, was at the printing office, heard Marshal John P. Green give orders to open the door. Now, this is at issue here, whether they forcibly opened the door, they broke into the printing office, or whether they just walked up and opened the door. This is a major issue here. Norton continues, Stephen Markham carried out the press and type, recollected Jonathan Dunham could not identify any others. No contention between the marshal and Francis M. Higbee. Marshall asked Charles A. Foster for the key, which he refused to give. Heard no threats concerning the destruction of the press at any time, end quote. And here we have some new details we can work with. The printers of the expositor were aware that the mob was forming to destroy their press, and clearly, at least some of them, attended the inevitable destruction that fateful night of June 10th. But apparently, Marshal John P. Green was kind enough to ask Charles Foster for the key to the printing office so he didn't have to break in, which of course Foster refused to give. And then somehow that gave them license to break into the office? I don't understand the logic behind this. But then in the heat of the moment, quote, for no contention between the marshal and Francis Higbee for that detail to be in the record is absolutely insane to me, because of course there was contention between Francis Higbee and the marshal, right? The marshal was there to destroy Higbee's press and silence his right to freedom of speech. To claim that Francis Higbee just sat back with folded arms and silently watched it happen, it's just such a blatant lie, right? But if he did just sit back and watch it happen, why did a riot happen? Why, if Francis Higbee, if the actual printer of the Expositor is just standing there, whatever, you guys can destroy my press, it's all fine. Here's my key. Here's my key to my office. If he was just standing there, then why did a riot happen? And if there wasn't a riot and everything was conducted peaceably without unnecessary noise, why were the charges of riot brought up in the first place? It doesn't make any sense to me. And let's be very clear here. The whole reason that Joe agreed to be arrested by the Carthage constable in the first place and to have his court hearing that we discussed 2 weeks ago was because the printers of the Expositor fled the night that it was burned, and they went to Carthage to swear out affidavits to the facts that they experienced, which generated the charge of riot, and that sent the Carthage constable to Nauvoo with a set of handcuffs with Joe's name on them. If not for the Expositor printers' immediate resistance and action, there wouldn't have been any criminal charges against Joseph Smith and the other 17 men responsible for destroying the press. Imagine being in this situation as one of the printers, right? Try to put yourself there. And I'm going to be very clear of what this will look like. If a couple of dudes with, the SCMC, that's the Strengthening Church Members Committee badges, broke into my house, ripped my laptop from under my wrists, and then threw it onto the sidewalk and set it on fire, I'd put up a bit of a fuss and I'd immediately report the crime. But because this is Nauvoo in 1844, the members of the ruling party of the city were judge, jury, and executioner. And they were the witnesses, and they were the attorneys, and they were the marshal, they were the policemen, they were also the militiamen, they were also the defendants and the prosecutors, and they were apparently victims of this claimed false accusation of riot. So it's just, it's nonsense, but it's consequential nonsense, and that's the major problem here. And an issue is going to become a central focus of this hearing, and that is a desk. That's one of the material pieces of property that claimed to have been destroyed was a desk. Now, we don't think much of this desk, but the next witness statement that we read is going to provide a bit of insight into the importance of this desk, and nearly every subsequent witness statement will hinge on this desk and its ultimate fate. What's at issue is not the desk, but the contents of that desk. This was the desk in the printing office which held important and irreplaceable documents connected with the Expositor. In the drawers of this desk, a person may find some land deeds or some promissory notes and other effects, but the most important document in that desk was the subscriber list to the Expositor. That's a single ledger book which contained the names of the hundreds or thousands of people who purchased a subscription to the Nauvoo Expositor, from which the prospectus was published on May 10th, all the way to the actual first edition published on June 7th. This ledger book would essentially contain a hit list of dissenters who purchased the Expositor throughout the city. The monetary value for subscriptions and the following witness statements that we're going to be reading here leads me to believe that at least 1,500 people subscribed to the Expositor after they published the prospectus of it. That list of names was a valuable resource for Joseph Smith to have, as each one of those people formed the foundation of the dissent movement in the city. It would be best for Joe if that book was destroyed, or the desk containing that ledger book were destroyed at least, but that book would be far more valuable in Joseph Smith's hands because it's a list of his enemies with their addresses and the terms of their subscription. That's invaluable information to a tyrant, right? Whatever happened to this desk or the papers contained in its drawers is a matter of historical mystery, and the hearing that we're reading through today reveals why it's such a mystery. This would be one hell of a document find if that ledger book survived to this day, but I haven't found anything about it. The next person to take the stand was O.F. Moiser, I guess. I don't know how to pronounce that last name. This person similarly witnessed the destruction of the press, but similarly, quote, could not identify any person. And, of course, he heard no loud talking or noise. There was no riot. There was no loud talking. There was no yelling. There was no shouting. There was nothing disorderly. Everything was quiet as a mouse. Of course, right? However, the next witness after O.F. Moiser provides a window into the events that no other witness reported before, some details of which cast a pretty ugly light on the marshal who forcibly entered the building and burned the press. Quote, P.T. Rolfe Sworn was at work in the printing office last Monday night. Chauncey Higby came in and said the council was about to destroy the press and took some papers from the desk. Marshall Green came with a company and demanded the key to the printing office, right? Foster and Higby forbid him. Door was opened by little, as witness thought. The press and fixtures were destroyed. Some paper and a desk belonging to Dr. Foster containing several $1,000s of property, $4,000 auditor's warrants, and other valuable papers, end quote. Okay, so that testimony is so much more troubling than just bringing it into the office and destroying the press, because a press can be replaced for a few $100s. However, the $4,000 worth of auditor's warrants and other papers and subscribers lists to the Nauvoo Expositor, possibly even including land deeds and stuff, that's a much greater personal criminal offense, right? This desk that contained all of these papers is really a massive issue here. So, in the previous example, not only did the Strengthening Church Member Committee guys break into my house and throw my laptop into the street and set it on fire, but they also found all of my personal papers, the title to my car, all of my emails with all of my supporters on Patreon, and a bunch of other documents that I need to conduct my business, and stole or burned all of them. And just for context, the $4,000 alleged here is about $137,000 in 2020 money. $4,000 would be a huge loss to any small business, like a small printing office or whatever. But when you account for inflation, that's $137,000 lost from a paper that had just published its first issue. Of course, that would break their company. And the destruction of their press, the thing that they were going to make all that money with, it's gone. It's all gone. It's all destroyed. Did Francis Higby or Charles Foster just sit back with their arms folded and just watch quietly as the mob destroyed their press? Is that really what happened? Is that really what we're supposed to believe here? I think the owners of that printing press had plenty of good reason to be infuriated at what the city marshal did at the direction of the prophet king of Nauvoo. Next, this same witness, P.T. Rolfe, who alleged the $4,000 worth of property, is cross-examined by the defense attorney George P. Stiles. Quote, did not know the amounts of warrants and papers, presumed they were destroyed, probably in the desk that was destroyed, right? Did not know they were destroyed, did not know whether they were destroyed, was from the office long enough to have them taken out. Said Marshal Green, Major General Dunham, Markham, Holmes, Perry, Edwards, and Harmon helped move the press, never knew anything against Joseph Smith personally, end quote. Now, the cross-examination here is pretty crucial because it was determining whether the $4,000 worth of paper and materials were actually destroyed by the Marshal and the Nauvoo Legion officers, or whether they possibly stole the goods, right? Or that ledger book that had all the names of the subscribers, gave it to Joseph Smith, right? This testimony, this cross-examination testimony, leaves open the possibility that P.T. Rolfe was out of the office for long enough that the printers, the business owners, the printers could have come into the office and carried the stuff out of it before the press was destroyed, instead of just outright, everything was destroyed all at the same time. Then, of course, P.T. Rolfe had to add in that he never knew anything against Joseph Smith personally, as some kind of insurance that Joe wanted in the court. So even if these other men were judged guilty for destroying the property or stealing the property or doing whatever they did with the desk and the printing press, Joe's name was clean, right? And that's how mob bosses work. They never get their own hands dirty. Next on the block was a guy named B. Warrington, who said he, quote, was present at the council when the bill passed to destroy the press, end quote. Now, to B. Warrington's statement, Joseph Smith raised an objection related to congressional immunity, of all things. Now, we need to spend a bit of time with Joe's objection here because I find it truly fascinating. Joe claimed, quote, all legislative bodies have a right to speak freely on any subject before them, and that Congress is not responsible for a riot which might arise on execution of their order by the marshal. That the execution of such order could not be a riot, but a legal transaction, end quote. So let's deal with that first. And honestly, I had to call on help from legal counsel of the show, Andrew Torres of the Opening Argument podcast, to try and tease apart Joe's objection here. And if you're not listening to Opening Arguments podcast, why not? It's the best podcast out there for current events. Anyway, the point that Joe makes here is that basically congressional immunity applies to city councils. And this is relatively reasonable because it's a doctrine in our Constitution that members of Congress are basically immune from civil lawsuits relative to their government duty. Because if a citizen could sue, like, let's say, if a citizen could sue their congressman, or let's expand it. Let's make let's expand the analogy. If a citizen could sue their president every time he makes a false statement, he would never leave the courtroom and he would have no time to actually run the country, right? Many people would argue that in certain circumstances, that's actually for the better, but we can also see how being able to sue legislators and presidents can create a system that can be weaponized against political opponents. And such is the case with congressional immunity, and that's the point that Joe was making here. The way that Americans hold their representatives accountable for lying or for passing laws they don't agree with or what they perceive as misconduct is by voting them out, not by suing them. And there are oversight committees and ethics organizations whose sole task is regulation of these immunity powers, but that's a separate and much larger and more complex issue. But the point Joe made here is an interesting one, that if a riot results from an act passed by Congress, then Congress isn't responsible. And he's using that as an analogy that the city councils should be covered by the same immunities that Congress is covered by. And this is actually true as well, because proving a crime requires a chain of causality. The issue has to be a proximate cause of the damages, and it has to be proven as proximate and causal. So, for example here, I'm driving my bright red Miata on a country road and I accidentally hit a bicyclist, right? They're injured and then the ambulance comes, but the ambulance doesn't get them to the hospital in enough time to save their life. I am legally responsible for their injury and their death because there's an unbroken chain of causality from me hitting them to their death. However, if that same person has a chance of surviving after I hit them and on the way to the hospital in the ambulance, a drunk driver hits the ambulance, preventing them from getting to the hospital when they otherwise would have survived, and the bicyclist dies because of that second accident, I'm legally responsible for their injury, but not their death, because the chain of causality was broken by the drunk driver. So with that logic, Congress, or Joe's city council here, passing a law or ordinance which results in a riot is nearly impossible to prove a chain of causality, legally speaking. And I know that seems counterintuitive, right? Congress passes a law and the people go out in the streets and rage about it. You think that the whatever damage those rioters cause is caused by Congress passing the law, but that's not how it works legally speaking. And I know that is counterintuitive, but the legal system often is counterintuitive. So Joe's counsel is first making the case that a riot didn't occur because witnesses were produced on their behalf who said that was the case. Then there was no riot, that everything was peaceable. There was no unnecessary noise, whatever. But then there's a second level of defense that he's making, which is more legally sound, that Joe's counsel can fall back on. That of, even if a riot did occur, you can't prove it was because of an ordinance being passed, right? So with this as the precursor, and like I said, this was confusing enough that I had to call Andrew Torres to help me kind of logic my way through this and understand Joe's objection here. But with that as the precursor, Joe goes on to make a subsequent point, quote, that the doings of the city council could only be called into question by the powers above them, and that a magistrate had not that power, that the city council was not arraigned here for trials, but individuals were arraigned for a riot, end quote. Now, this is a super interesting point in his objection. Now, given the premise proposed of, city council immunity being the same as congressional immunity, Joe made the case that the 18 people, including himself, who were arraigned in the municipal court for riot, were arraigned in as private citizens, not as members of the city council. My question is, was this actually a better argument? If they were brought in as members of the city council, they enjoy the powers of basically congressional immunity. But if they're private citizens, they're all vulnerable to the charges of riot that's at issue in this trial. And I honestly think this is because Joe had a deeper motive in making sure the trial was against private citizens instead of against city councilors. And that motive is the color of law, right? If the conduct of the city council is brought into question as a result of this trial, it puts the legitimacy of his entire city council in jeopardy. However, if this riot charge can be pinned on private citizens instead of their actions as city councilors, the government of Joe's little fiefdom is no longer at issue. It's the individuals themselves and their conduct that's at issue. Now, the exchange of that means that himself and his counselors are vulnerable. They're no longer covered by that city council immunity, but the council itself remains immune. Besides all of this, the hearing was done under color of law. It was conducted so it looks as if it's a legitimate hearing, but the conclusions were already decided before the hearing was ever called, right? Joe and his conspirators were never going to answer for any of these crimes because his municipal court would never rule against their prophet, priest, and king, even the great and immortal Joseph Smith, right? So he makes a final point in his objection, quote, if the city council had transcended their powers, they were amenable to the Supreme Court, and that Judge Thomas had decided that an action could not lie if no riot had been committed, end quote. So that passage adds just more context to Joe's overall objection that these men were acting as citizens and they weren't arraigned in court in their official capacity. If this court were determining the validity of laws and ordinances passed by the city council, those laws and ordinances are supposed to be adjudicated at higher courts. He says the Supreme Court in his objection, but that's not actually accurate because first, if the people were going to appeal this case or the findings of this case, it would go to the circuit court. It's at Carthage, right? That's the hotbed of anti-Mormonism, and it would not treat the prophet and his boys with an I, right? The prophet and his boys so favorably. So Joe, of course, preferred that this go straight to the Supreme Court, which it absolutely would not. But the court apparently agreed with Joe's overall objections, and they ruled, quote, court decided that the gentlemen arraigned were arraigned in their individual capacities and could not be recognized by the court in their official capacity, end quote. And this is consistent with the law and, the law of the time. And according to Andrew, it was the best defense that Joe could put forward, legally speaking. But once again, we have to keep in mind the tightrope that Joe was trying to walk in making the individuals on the city council liable for their actions in an effort to not call the legality of his city council at large into question. So at this point, George P. Stiles, the attorney defending Joe and the city councilors as private citizens, instead of in their official capacity, he moved to dismiss the prisoners for want of a case being made out. That's a quote. Counselor Bonney, the prosecuting attorney, quote, read the Riot Act and pled a case had been made out, end quote, and the court decided to overrule the call for dismissal, and they continued to hear more statements from witnesses. Next, a guy from New York, Dr. Joseph R. Wakefield, a Joseph Smith crony, took the stand, and he once again makes the case that there wasn't actually a riot, but if there was a riot, it was the fault of Francis Higbee, not Marshal John P. Greene or Major General Jonathan Dunham of the Nauvoo Legion. Quote, Dr. J.R. Wakefield said he went on the hill after the order passed the council, saw some portion of the Legion collected, walking quietly along as though they were walking to the Dead March in Saul. There was no noise or tumult. That's him saying, oh, there was no riot. What are you talking about? And then he says, Higbee asked the marshal his authority. Marshal stated his authority from the mayor for abating the nuisance. Higbee set them all at defiance. If there was a riot, it's Higbee's fault. That's what he says there. Higbee set them all at defiance. Some 12 men were called out who went upstairs and opened the door. Did not know how the door was opened. Did not know how the door was opened. Maybe it was a key. Maybe they bashed it in. There was not more than one thump. There was not more than one thump. It's actually in his witness statement. He continues. Marshal Greene asked one of the officers if anything was destroyed except what belonged to the press, and the officer replied, no, all was done in perfect order, as peaceably as people move on a Sunday. Was present all the time. All that was done in their official capacity as officers of the city. End quote. So at issue here was the force which was used to break into the Expositor printing office and Francis Higbee refusing to give up the keys which required the marshal and the legionnaires to break into the office in the first place. If they can dissociate this act of violence from the riot, it further breaks that chain of causality that we talked about earlier. But if they break into the office and a riot ensues immediately after, it's harder to claim that there isn't causality there unless you can pin the causality on Francis M. Higbee, right? So if they can, it's amazing. So to kind of briefly provide a comment on the meta-analysis here, this hearing would be vastly different if Higbee himself was allowed to testify, right? If the actual victims of the crime could give their side of the story, this hearing would be so much different. Joe's court could always produce witnesses on Joe's behalf, right? And any witnesses who might contradict the narrative that Joe's counsel was weaving here, they would never be called to the stand because of course they wouldn't. And because we aren't able to get the statements of Higbee or Foster's or the laws in this whole ordeal, the Nauvoo Municipal Court is at liberty to create whatever truth they feel will best serve them. By the end of the hearing, the foregone conclusion will be arrived at, which will set into sequence a chain of events that led to vigilante justice, because no real justice could be had in Nauvoo. But to take a step back even further, we can see the mechanisms at work here. We can see the turning cogs. This is how tyrants rule. They establish the order of society and the people follow their rules. When challenges to their power occasionally crop up, they can exercise the powers of their own system to quash that insurrection. Like a game of whack-a-mole, but Joe and his boys have a hammer of the Nauvoo Municipal Court, which could whack 7 moles with a single swing. However, this hold on tyrannical power was tenuous because the remedy for terrible laws being passed by corrupt city councilors or congresspeople is by voting them out, right? Sure, Joe's Banana Republic works when 90% of the city are Mormons and they all vote in goose step behind their divine leader. But what happens in 5 years when only 70% of the voting public of Nauvoo are Mormon? What happens in 15 years when Mormons are only, 49% of the voting public? That power slips away. And when people are mad, they vote. When voting isn't immediate enough of a fix, they protest. When protests aren't effective, they become riots. When riots don't do the trick, riots escalate into rebellion, and soon a government is locked in the turmoil of a revolution. We just don't know where on that timeline of events the Nauvoo government was. The model that Joseph Smith was using to retain his complete and total power was exceptionally vulnerable, and time was ticking before it teetered off the precipice that he had manufactured. I want to relate a brief anecdote. Back in 2017, I drove across country and I visited all of the Mormon history hotspot sites. One of those sites, of course, was Nauvoo. And in the Nauvoo city, the church has a visitor center, and they've essentially turned it into a museum, which has a number of Nauvoo history artifacts that are, in the actual museum. One of those was a small wooden box inside of a glass case, and I took a picture of it and posted it on social media. And underneath this wooden box was a small plaque that said Nauvoo Municipal City voting box. This is where people would cast their votes. And when I posted that, I don't remember who said this, and I'm sorry that I don't remember your name, but somebody commented and said, the most useless thing in Nauvoo history. Because it was. The elections were foregone conclusions. The elections were manufactured. They were a farce. They were just theater at the end of the day. Because Mormon leadership controlled everything in the city. But how long until that was no longer the case? That was really the larger question here. Back to the story. The next witness called exemplifies this problem of, witnesses could be produced who would say anything necessary in the court. Quote, E. Wingate, such a great name, E. Wingate of Boston concurred in Dr. Wakefield's statements, that was the previous testimony, was by the door when it was opened and knew that nothing more than a knee was put against it. All was done quietly, right? This is once again trying to dissociate the violent act of breaking into the office from the riot that immediately ensued. If they just sort of, walked in, if they just sort of waltzed in or hopscotched into the office and then pulled the printing press out and burned it, and then, a riot spontaneously erupted after that, then, hey, the chain of causality is broken. But if they broke into the office with a sledgehammer and Francis M. Higbee and Charles Foster were there and everybody is losing their mind, and that's the inciting of the riot, that violent act of crashing the sledgehammer into the door of the printing press is linked in causality, right? So there was nothing more than a knee put against the door to get in. All was done quietly. He was present in the city council when the order was passed. Nothing was said in the council except what was said in capacity of councilors and aldermen, which is something we'll talk about in a little while when it comes to Thomas Sharp and the Warsaw Signal. Was by the door all the time when the press and type and things used in connection with the press was destroyed. There was no other property taken from the building, end quote. So how do we square that statement with the previous statement from P.T. Rolfe, which claimed that upwards of $4,000 of materials and documents and property were destroyed in addition to the press and the type? We can't square these statements. We don't do it because they can't be reconciled. We simply forget that the previous witness statement said anything about the $4,000, and we take what E. Wingate and Wakefield said, that it was only the press and the type which was destroyed. Also, hey, no sledgehammer was used to break into the printing office, right? It was just a guy's knee that he used to just kind of gently nudge the door open. You see, this statement doesn't comport with all the other evidence presented in the previous trial from a week ago that we discussed, nor does it comport with the previous statements in this very hearing. It illustrates to us that they were in the process of writing their own narrative of the story. This is manufacturing history as contemporary events unfold. And once again, the most pressing issue in both of these hearings is that none of the witnesses who were actually the victims of the perceived crime were allowed to testify. If the Fosters, the Higbees, or the Laws, Sylvester Emmons, Charles Ivins, if any of the printers or the editor of the Nauvoo Expositor were here to testify to their version of the facts, this would be a very different hearing, and we would learn a lot more from the record than what currently exists. At this point, Whiteout Willard Richards, the clerk for the city council, was called to the stand, and he read the ordinance concerning libelous publications, the resolution declaring the Expositor a public nuisance, and the marshal's reply to Joe's order that it was carried out successfully. After that, Dr. Joseph R. Wakefield took the stand again to continue to weave this narrative that the city council and Joe were spinning together in the court. Wakefield, quote, heard Marshall tell the officers and men to hurt no property except the press, type, and fixtures. And after the abatement, Marshall inquired if his order had been obeyed, and the officers said it had, end quote. The troubling fact of the matter is that every man who executed these orders was a Danite who swore to protect the prophet with their own life. Of course they would lie on the stand. And they were accountable only to Joseph Smith, who has exhibited a pattern of deception his entire life. We can't trust anything any of these men are saying, especially at such a chaotic and tense time of Nauvoo history, which is even further exemplified when E. Wingate takes a stand again and weaves another tall tale. The witnesses following him continue in the same vein concerning the desk that was supposedly not burned, which supposedly didn't contain the $4,000 worth of documents, even if it was burned, because these guys saw Foster take the documents out of the totally not burned desk before the desk was totally not burned, right? Here we go. Are you having trouble following along? Because I sure am. Quote, E. Wingate heard Mr. Foster ask Higbee for the key to the office and afterwards saw him deliver the key to Mr. Higbee. There was nothing destroyed but what pertained to the press. Addison Everett of New York sworn, saw the press and type taken out and burned, saw no other property burned. Desk might have been taken away before, should not have seen it if it had been, saw no desk burned, does not believe that any desk was burned. Joel S. Miles sworn, Foster said his docket was not burned. Witness was sure that Dr. Foster said he had taken other papers out of the desk. It's like, what's the truth here? What's actually happening? And of course, Dr. Foster isn't here to tell his side of the story. Anyway, W.G. Ware called again, saw Charles Foster coming from the office and go into Foster's house with books under his arm, looked like account books, saw nothing but the press and fixtures brought out except a chair, and the marshal ordered it carried back. So apparently they brought out the press and fixtures to burn those, and somebody brought out a chair, but Marshal Green was like, no, we're not burning chairs here. Just take the chair back and put it at the desk that totally doesn't exist in here. E. Wingate recalled, stood close by the door, could see all that was done, did not believe a desk could be brought out, and he did not see it. End quote. It's... These witnesses put on a stunning performance, didn't they? Hey, there was no desk burn. There may have been a desk in the office, but it wasn't removed. There may have been papers in the desk, but it wasn't removed or burned, but the papers were removed by Foster before the marshal destroyed the press and totally didn't destroy the desk, which had the papers in it. The marshal had to break into the printing office with just his knee, but he asked Francis Higbee for the key first, and he refused to give up the key, so he had to break in, but it was only with his knee, and it was done quietly, and nobody took any notice, and no riot happened. And if a riot did happen, it was all the fault of Higbee and Foster, but there wasn't a riot, and if there was a riot, we can't be blamed for it. But wait, there's more. Quote, Dr. Wakefield recalled, Joseph Smith and Hiram were not on the hill at all that evening, end quote. So whatever happened that night, I hope you're just as confused as I am, Joe and Hiram didn't participate whatsoever. So they can't possibly be guilty of anything like riot or burning the desk that had this $4,000 of property in it, right? And to drive the point home, a guy named Joseph W. Coolidge, another Joseph Smith crony, took the stand for the final testimony of the day. Quote, Joseph W. Coolidge was discharged by the court and sworn. Charles Foster asked Francis Higbee for the key to the office. Higbee hesitated. Foster said he wanted to get a desk that had some valuable papers in it. Foster got the key and went in. Did not see him remove the desk, might have removed it, and witness not see it. There was no desk burned, end quote. That's the entire record of the court. And, of course, the desired, inevitable conclusion had been reached. Quote, the counselors submitted the case without a plea, and the court discharged the prisoners. End quote. June 17th was an eventful day. After Joe and his 17 co-conspirators were released from this asinine farce of a trial, Joe took to writing letters and proclamations while his various henchmen continued their business in the city. Stephen Markham, Piggy Bank Steve, as we've called him before, made an affidavit before Whiteout Willard Richards stating, quote, The public papers, especially the Warsaw papers meaning Thomas Coke Sharp's The Warsaw Signal, right? And from reports from the various precincts, a mob may be expected to make an immediate attack upon the citizens and city of Nauvoo on account of the gatherings at the various precincts and threats to exterminate the Latter-day Saints, end quote. You see, Stephen Markham had just returned from Warsaw with a copy of the most recent extra printed by the Warsaw Signal, which contained the charge of the citizens to rise up and exterminate the Mormons that we read 3 weeks ago. Now, he saw mobs forming, and the only thing the Mormons could do at this moment in time was to collect affidavits like this and prepare the city for war, which is exactly what Joe did. Because he wrote a proclamation on the evening of the 17th, just a few hours after the hearing that we just read, quote, "Proclamation to John P. Green, Marshal of the City of Nauvoo. Sir, complaint having been made to me on oath that a mob is collecting at sundry points to make an attack on this city, you will therefore take such measures as shall be necessary to preserve the peace of said city, according to the provisions of the charter and the law of the state, and with the police and legion see that no violent act is committed," end quote. And a separate proclamation went to Major General of the Nauvoo Legion, Jonathan Dunham, stating, quote, "You are hereby commanded to order the Nauvoo Legion to be in readiness and to assist said marshal in keeping the peace and doing whatever may be necessary to preserve the dignity of the state and city," end quote. But another order was sent to Jonathan Dunham, which took into account what had transpired the last time that Joe issued similar orders to destroy the Expositor Press. Quote, "You are hereby instructed to execute all order of the marshal and perform all services with as little noise and confusion as possible." Don't cause any riots, all right? I know how this went down last time. I just got out of court because you messed it up the last time that I told you call out the Legion. Make sure that everything that you do today is with as little noise and confusion as possible. And take every precaution to prevent groups of citizens from gathering on the bank of the river, on the landing boats, or otherwise, and allay every cause and pretext of excitement as well as suspicion, and yet let your operations be efficient and decided, end quote. This was a prophylactic measure to keep from being arraigned in for riot again. If Joe had an order like this that he could point to after another riot, he could claim that he told Jonathan Dunham to not rile up the citizens, not cause a riot, right? But if they happened to be riled up into a riot, it totally wasn't Joe's fault because he had this document, right? He was preempting another hearing like the one that he had just experienced that day. And he wanted documents to show that there was no riot that was going to be his fault. But he wasn't done just yet because Joe got some troubling intel. Quote, "It is reported that William and Wilson Law have laid a plan to burn the printing office of the Nauvoo Neighbor this night. I therefore stationed a strong police round the premises and throughout the city," end quote. Now, whether or not William and Wilson Law were actually planning to burn the Nauvoo Neighbor printing press and pie the type as it happened to their press, the Nauvoo Expositor, we'll never know. Because I can't find any other document than what's recorded in the history of the church, which corroborates that there was indeed a plan here. However, Joe's reaction was expected, and he set up a guard overnight to make sure that the laws didn't put into effect any plan to burn down the Nauvoo Neighbor. Even if it was nothing more than a rumor that was possibly circulated by the laws themselves to see how the prophet would react to that intel. Right? There's a whole lot of strategizing going on all sides of this dynamic here. There was another fire to deal with, right? And that came from the Warsaw Signal, right? Thomas Sharp had printed allegations that Hiram's sidekick Abiff Smith had threatened his life and his paper, the Warsaw Signal, in the city council meeting that declared the Expositor a public nuisance. Hiram said he would give Long-Nosed Sharp some snuff that he could sneeze at. And Joe put the Nauvoo Neighbor to work to answer this anti-Mormon propaganda with some Mormon propaganda. Quote, "To the public, we whose names are undersigned, having seen in the Warsaw Signal containing the proceedings of a meeting, an anti-Mormon meeting, held at Carthage on the 13th instant, many statements calculated to arouse the indignation and wrath of the people against the citizens of Nauvoo, do certify that Hiram Smith did not make any threats, nor offer any reward against the Signal or its editor in the city council." And there are 16 signatures of Joseph Smith boys, end quote. Joe also called together his personal vanguard to appear before the Nauvoo mansion in full battle regalia. He sent an order to Colonel A.P. Rockwood, not O.P. Rockwell, but A.P. Rockwood. And this shows us that Joseph Smith was absolutely expecting a mob to come into Nauvoo that night or the next day, which were absolutely reasonable expectations given the events of the past few days. Mobs were forming in the nearby anti-Mormon hotbed cities of Carthage and Warsaw, and it was only a matter of time before they showed up in the outskirts of the city of Nauvoo. Thus, Jonathan Dunham's orders to have the Nauvoo Legion patrol the wharf and to break up any large gatherings of people. This is what Joe sent to A.P. Rockwood, who was, of course, a Danite and a colonel in the Nauvoo Legion. Here are Joe's orders. Quote, "You are hereby commanded to notify my guard and staff to appear at headquarters," this Nauvoo mansion, "without any delay, armed and equipped according to law for military duty and inspection with powder and ball," end quote. Okay, a lieutenant general doesn't call together his colonels and his personal bodyguard platoon and a staff fully armed with powder and ball because he wants to have a parade or he's going to take them all out for drinks. He does it when he expects that his life is in imminent danger, which it was, right? The reports of the laws wanting to burn the Nauvoo Neighbor, the growing mobs in Carthage and Illinois with reinforcements from Missouri, the letters from Mormon settlements all over the state that mobs were entering their cities and demanding their guns. And then Joe responding by telling his Uncle John Smith and his friend Isaac Morley to only give up their guns if you give up your lives with them. I mean, wow. Just, there were too many moving parts that were all threatening Joseph Smith, and he wanted an active bodyguard fully armed with powder and ball around his house, patrolling the landing of the Mississippi a few blocks from his house, and guarding his own printing press. Add into this, only an hour before midnight of this incredibly eventful day, Joe received a messenger. Quote, "A Negro came into my office with an open letter without any date or name and said that Dr. Robert D. Bob the Builder Foster gave it to him at Madison to give Henry O. Norton. In that letter, Foster said that Dunham and Richards swore in my presence that they would kill Foster in 2 days, and that there was a man in Madison would swear he had heard them say so at my house," end quote. So now Joe had intercepted a letter that was going to a dissenter with intel that somebody heard 2 Danites telling Joe that they would kill Robert D. Foster in 2 days. And that person who sent the message was willing to testify to the fact. As this letter was intercepted at 11 p.m., no action could be taken to deal with that until the next day. However, one of the final actions of that evening was to put William Wines Double-Dub Phelps to work to manufacture some propaganda to be published in the Nauvoo Neighbor Extra for that evening. Here it is, the whole thing. There's a bit to talk about. Anyway, quote, "To the public. As a soft breeze in a hot day mellows the air, so does the simple truth calm the feelings of the irritated. And so we proceed to give the proceedings of the city council meeting relating to the removal of the Nauvoo Expositor as a nuisance." Starts out reasonable. Here we go. Let's see if it provides the rest of the article is reasonable. "We have been robbed, mobbed, and plundered with impunity some 2 or 3 times. And as every heart is more apt to know its own sorrows, the people of Nauvoo had ample reason when such characters as the proprietors and abettors of the Nauvoo Expositor proved to be before the city council to be alarmed for their safety. The men who got up the press were constantly engaged in resisting the authority or threatening something. If they were fined, an appeal was taken, but the slander went on. And when the paper came, the course and the plan to destroy the city was marked out. The destruction of the city charter and the ruin of the saints was the all-commanding topic. Our lives, our city, our charter, and our characters are just as sacred, just as dear, and just as good as other people's. And while no friendly arm has been extended from the demolition of our press in Jackson County, Missouri, Without law to the present day, the city council, with all the law of nuisance from Blackstone down to the Springfield Charter, knowing that if they exceeded the law of the land, a higher court could regulate the proceedings, abated the Nauvoo Expositor. The proceedings of the council show, as sketched, that there was cause for alarm. The people, when they reflect, will at once say that the feelings and rights of men ought to be respected. All persons otherwise who, without recourse to justice, mercy, or humanity, came out with inflammatory publications, destructive resolutions, or more especially extermination, show a want of feeling and a want of respect and a want of religious toleration that honorable men will deprecate among Americans as they would the pestilence, famine, and horrors of war. It cannot be that the people are so lost to virtue as to coolly go on murdering men, women, and children. No, candor and common sense forbid it." End quote. This was an attack by the Nauvoo Neighbor aimed in all directions, right? Like a horde of cockroaches scattering from a single focal point of light. This was a declaration against all enemies of the church. And more importantly, it made all enemies of the church equal, right? It called on the persecution narrative experienced and embraced from Missouri, and it paints all the people who are enemies of the church today in the same discredited light as those enemies from a decade ago, when those people burned the Mormon press in Jackson County. Thousands of people living in Nauvoo at this time who received a copy of this Nauvoo Neighbor Extra had suffered through the Missouri Mormon War and the exodus to Illinois. Invoking that trauma is a powerful mind control mechanism that Joe had used so many times that it's survived even to today's generation of Mormons. The justifications provided here are paper thin. The publishers of the Nauvoo Expositor refused to cease publication when told that their paper was inflaming the mob and it will cause the destruction of the Nauvoo Charter and the breaking up of the city as they knew it. That was literally their entire point to publishing the Expositor, right? The publishers published the Expositor because Nauvoo was so incredibly corrupt and there was no legal recourse beyond exercising their freedom of speech. The only way to wash away the corruption of Nauvoo was to revoke the charter and start with a clean slate. The fact that they wouldn't listen to the members of the city council government telling them to not publish the Expositor reveals how corrupt Nauvoo really was. And at the end of the day, it didn't really matter all that much. They refused to follow those orders because the city council just destroyed their printing press and their right of freedom to speech anyway, right? The argument made here is that these guys just didn't like how corrupt we were, and if we allowed them to continue publishing more editions of the Expositor, then we couldn't keep on corrupting, so we corrupted super hard by corruptly destroying their press. Yeah, that's the whole problem that the Expositor sought to end in the first place. And what's even more remarkable about all of this is the whole issue the Expositor raised with Jeremiah Smith. You know, and Jeremiah Smith, he was the distant cousin of Joseph Smith. He was a fugitive, and he was being harbored as a fugitive in the city, and the municipal court covered up for him. Once the Expositor was published, pointing to Jeremiah Smith as the quintessence of Nauvoo criminal justice corruption, new arrest warrants were issued for Jeremiah, and he immediately went into hiding, which just exacerbated the problem. Joe received communication from Burlington, Iowa Territory, a Mormon settlement there. Quote, "Dear Sir, I write to inform you that Jeremiah Smith arrived here yesterday in safety and free from arrest. He desires through me to thank you for your kindness and attention to him while at Nauvoo." End quote. One of the central complaints of the Expositor was with this Jeremiah Smith character, and Joe continued to move Jeremiah around the Mormon settlements of his boys where Jeremiah wouldn't be arrested. Receiving this communication when Joe was accused of harboring this fugitive, when he received this communication, it's absolutely criminal. This is yet one more nail in Joe's coffin, proving his criminality. All right. Okay. Let's let's take a breath, okay, and consider everything in the abstract here for a few minutes. Today's episode covered one day of events And each subsequent day that we're going to continue covering in each episode of the podcast becomes more complicated and eventful when more than half of Joe's days aren't monopolized by a sham court hearing like this episode and today was, right? Everything today comes from just page 577 to 585 of volume 6 of the Vogel History of the Church. So let's try to kind of extricate ourselves from the details to get a larger view of what's happening at the higher level here. Joseph Smith was not an idiot, right? I've said that so many times on the show, but it bears repeating. He may have done some stupid stuff from time to time. He may have made some split-second decisions or a series of bad decisions that cost the lives of hundreds of his followers. He may have been uneducated. He may not have read many books and had plenty of bad influences in the form of his mentors from his youth. He was incessantly narcissistic and self-centered. He's also incredibly intelligent. It requires an intelligent person who makes so many bad decisions to still rise to power in spite of those bad decisions. Only intelligent people can recognize errors and adjust their future conduct based on what they learned from those prior mistakes, and Joseph Smith did exactly that. Intelligence, untempered by education, are the ingredients of a revolutionary mind. Joseph Smith refused to acknowledge that this world is ours, not his. Wisdom dictated that he needed to play by the rules of the world just enough to not become the pariah that he deserved to be, but the greater his power became, the less that the rules of the world mattered, and the less that his radical conduct was mitigated by societal expectations. With that said, even Joe could recognize that this time was different. He had been involved in over 30 legal cases throughout his life, and we've only covered like a dozen of them in 200 episodes of the show because most of those are relatively inconsequential and they're civil instead of criminal, and I usually spend more airtime on the criminal stuff, but this conflict with justice was different than all of his previous battles. Every minute of every day after the Expositor was destroyed was filled with a mix of covering tracks and paving a clear path ahead to victory. These two Nauvoo Municipal Court hearings in a week's time were an effort to cover his tracks. In just a week ahead of where our timeline currently rests, Joe will instruct William Clayton, or as we know him, Quilliam Claypen, to burn or bury the minutes of the Council of 50 because it's incredibly treasonous contents. Multiple extras were printed in the Nauvoo Neighbor to justify the destruction of the Expositor Press as a lawful act in a system which habitually flaunted the laws. All of these things cover up for past actions, but what about paving the way for victory ahead? Well, Joe called his closest advisors home from their far-off missions in the eastern states so that he could more comfortably surround himself with people who he knew and who knew him and could diversify the workload of fighting the entire state of Illinois more effectively. They could also advise him in ways that the remaining skeleton crew in Nauvoo were incapable of doing. Come hell or high water, Joe put all his platoons of Nauvoo Legionnaires around the state on high alert, ready to consolidate to Nauvoo and make a final stand as had happened in far western Adirondack in Missouri just 6 years prior. He was in constant contact with the governor, and he sent multiple contingents of messengers to relay messages and hold meetings and to convey court proceedings to Governor Thomas Ford, His Excellency, right? Joseph Smith set up a couple of his boys in the Masonic Lodge to constantly record affidavits from messengers entering the city and to document the movements of the anti-Mormons in the surrounding cities. And most importantly, Joe put his propaganda ministers to work to fabricate a version of himself which wouldn't be repugnant to the courts if he did wind up in cuffs and documents were subpoenaed. This is how he paved the way to what he could see as victory. And all of these pressures were coming to a head and chaos continued to grip the Mormon settlement. Joseph Smith gave Quilliam Claypen a new task. Keep a new journal. Whiteout Willard Richards and Quilliam Claypen were already keeping journals for Joseph Smith for the past 3 years, but this journal was special and it got its own little notebook. It's a long-forgotten relic of Nauvoo history, and it's buried deep in the Joseph Smith Papers website under the title of Appendix 4, William Clayton account of Joseph Smith's activities, and that's it. And it covers only from June 14th to June 22nd, 1844, making it a very unique artifact of Mormon history. According to the Joseph Smith Papers introduction to this document, quote, "Why William Clayton recorded this daily account of Joseph Smith's activities is unclear. Though the record contains daily entries from 14th to 22nd June 1844, it is not part of Clayton's personal journal, which covers the same time period. In every case, the entries in the account are longer and more detailed than the corresponding entries in Clayton's own journal, and significant differences in content suggest that neither record was copied from the other. The record does not include a title page or other written explanation to indicate the purpose of its creation." End quote. Personally, I believe this delightful little book was a daily journal that Joe told Quilliam Claypen to keep as what he would present if he were arrested and documents were subpoenaed concerning Joe's daily activities during this tumultuous time. It also includes some very interesting points of theology sprinkled in with justifications of waging war against the citizens of Illinois. For example, Friday the 14th, the first entry, quote, "Joseph Smith prophesied in the name of the Lord that if they did mob us, it would be a precedent to come down upon their own heads with fury and vengeance." End quote. Saturday the 15th, the second entry, quote, "Joseph Smith told others in the Nauvoo Mansion bar room a dream concerning his father killing a man who attempted to stab him. He also spake concerning key words. There's an illegible word there. The illegible key word was the first word Adam spoke and is a word of supplication. He found the word by Urim and Thummim. It is that key word to which the heavens is opened." End quote. Unfortunately, the word is illegible, so we don't know what that key word is that actually opens up the heavens that he found out through the Urim and Thummim. Whatever, unfortunately. But it continues with some of the events that we've discussed these last 3 episodes, but the entries are otherwise fairly inconsequential. However, one entry is incredibly notable, and it describes the 17th, June 17th, which is the day that this entire episode has covered. The entry refers to Jeremiah Smith. That Joe received a letter saying that Jeremiah had arrived in Burlington free of arrest. Instead, however, this special journal records it as follows, quote, "A letter was received stating that Jeremiah Smith was acquitted by Judge Nathaniel Pope." End quote. The letter that Joe received said nothing of the sort. But if this little journal that Claypen kept was to be presented to the courts after Joe's inevitable arrest, this line would go a long way in defending the expositor's accusations about Nauvoo harboring Jeremiah Smith as a fugitive. It's little signals within the contents of this special little journal that lead me to believe that it was supposed to be a public document, which would allow Joe's propaganda ministers to conceal his actual journal, which was full of treasonous activity, just like the Council of 50 Minutes that Joe instructed Quilliam Claypen to burn or bury. I believe that keeping this special little journal was one step taken to pave the way to victory in overcoming this new wave of opposition and insurrection. But just like every action fighting inevitability, it was all for naught. The last entry that was made in this special little journal was on June 22nd, the day that Joseph Smith left Nauvoo to go into hiding and evade arrest. Following that entry are 15 blank pages in the notebook that would never be filled because the person at the center of the document succumbed to inevitability. He was dead. That's going to do it for our main segment today. We do have a new patron over at patreon.com/nakedmormonism. That is by Marcy. New patron Marcy, and to all of our patrons who support the show financially, patreon.com/nakedmormonism. From the bottom of my heart, thank you so very much. Patreon supporters did get a little bit of extra content this week. Braden and I over on the Glassbox podcast decided to play a bit of a stay-at-home current events kind of drinking game, and we did Mormon culture versus Mormon history, and we took video of it. So I wanted my patrons over here on the Naked Mormonism feed to also enjoy the video of that if they would like to. So patron supporters, you get extra links, extra content this week that has links to the YouTube videos of us getting together and playing that drinking game. Braden decided to trivia game me with Mormon culture, which is definitely a significant weakness of mine, and I hit him with a bunch of Mormon history questions, which seemed to be a weakness of his. But it turned out to be, well, it was fun for us. Listening back to it and editing it, it was a disaster, but we sure had fun, and I think that's really what matters. So if that's something that interests you, go check your Patreon exclusive feed if you are a supporter of the show. Let's go ahead and shut it down for the night. I want to thank everybody for sticking around. If you leave iTunes reviews or reviews on whatever podcasting app you use, that's super helpful. And everybody who has done that, thank you so very much. And, to everybody else for sticking around to the end of the show, thank you so much for lending me your ear. Hope to talk to you next time here on the Naked Mormonism Podcast. This podcast is produced with the help of Julie Briscoe as social media manager and Brian Ziegenhagen as audio engineer. Music is written and produced by Jason Camo of aloststateofmind.bandcamp.com and used with permission. Legal counsel is provided by Andrew Torres of the Law Offices of P. Andrew Torres and the Opening Arguments podcast. Naked Mormonism is a production of Ground Gnomes LLC. Copyright 2020. All rights reserved.